Welcome to the European Investment Screening webinar. For those of you who don't know me, I am Christina Schütt-Liaus. I am the Regional Director in the Northern Europe region for the Department for International Trade, also known as DIT. DIT is the ministry within the UK government responsible for encouraging investment into the UK, amongst many other things. And I'm responsible for the European investment part into the UK. I'm sure that everyone here is aware of the wave of various pieces of investment screening legislation being implemented across the globe. On the back of an EU regulation from 2019, foreign direct investment laws are now being introduced across Europe, while the US, Australia, and Japan have already strengthened their investment screening regulation. The UK's own National Security and Investment Act will be coming into force on the 4th of January next year. So a date to remember, the 4th of January 2022. This act will give the UK government new powers to scrutinise and intervene in cases of investment that are relevant to the UK's national security. It's important that investors into relevant sectors are aware of these changes because sensitive transactions completed without approval could be unwound and non-compliance could result in civil and criminal penalties. However, the UK's National Security and Investment Act has also been designed to be as light touch and transparent to investors as possible. I think the most important words here are light touch and transparent. It will ensure that future investment screening decisions made by the UK government are made to predictable and legally defined timelines and processes. So predictable timelines and processes. We thought that it would be really helpful to organize this webinar to explain why the provisions of the NSI Act are, what the provisions of the NSI Act are, what steps investors need to take to remain compliant, and how these changes will help and not hinder investment into the UK. We also wanted to take this opportunity to explore how this new UK legislation compares to equivalent regimes in Germany, in France, and in the Nordic and Baltic region. To help us on this journey, we have invited an expert panel who are with us today. You will meet Chris Blairs, who will provide an overview of the UK's National Security and Investment Act. Chris is a Deputy Director in the Investment Security Unit in the Department for Business, Energy and Industrial Strategy, also known as BASE. And before that, he was the Deputy Director for Competition Policy at BASE. Next, you will meet an impressive panel of international lawyers. First of all, Nikolaj Juul Hansen. Nikolaj is the managing partner at Magnussen Law based in Copenhagen, but covering the entire Nordic and Baltic region. Nikolaj has years of experience within mergers and acquisitions, corporate law and financial transactions, and have practiced internationally also from a base in London. You will also meet Lionel Lesure. Lionel is both a French and an Italian qualified lawyer advising on private mergers and acquisitions and French EU and EU competition law, and Lionel is based in Paris. Last but not least, you will meet Christian Bürger from the Cologne office of the German law firm Görg, one of the top independent business law firms in Germany. Christian is also specializing in German and European competition law, as well as foreign direct investment review. After the panel presentation, we will have a 20-minute Q&A session, so by the end of this webinar. So if you'd like to ask a question, please just raise your hand and use the icons on the top of your screen. Or you can also post any questions that you might have on the Teams chat here on your right side, and I will then relay them to our panel of experts. If you're looking for more detailed information, please can you make sure your microphones are turned off. If you're looking for more detailed information, you can find further background on the National Security and Investment Act on the UK's official governmental website. It's called gov.uk. I will also put that link in the chat. You can just type NSI into the search bar on the front page and you will get loads more detail. And if you still have specific questions after today's session, please don't hesitate to drop me an email or reach out to the IT investment colleagues in the country where you are. They are all based at the British Embassy in your country. So now, without further ado, I think it's time to get this webinar started, and I will start by passing the word to Chris. So Chris, over to you and welcome again.
Christina, thank you very much for that warm welcome, and thank you for the invitation to address this webinar this morning. It's a really important opportunity to talk about not only the UK's new National Security and Investment Act, but also to set it in the context of other approaches to investment screening across Europe. So it's a really good opportunity today. If we go on to the first slide, please. I thought I'd start by talking through some of the thinking behind, the rationale behind why we introduced the National Security and Investment Act. And I think the place to start is the UK's long reputation for its openness to investment and its openness to trade, to international trade. And nothing in the new National Security and Investment Act changes in any way that reputation, that openness to investment and trade. But that openness always has to come with appropriate safeguards to protect national security. And the legislation that the UK has been using for the last 20 years is the Enterprise Act 2002, which many of you on this call will be familiar with, but was essentially a piece of competition legislation designed to deal with mergers and takeovers, with essentially a ministerial override in certain situations of public interest, including national security. And because it was a piece of competition legislation, it had characteristics about it which don't really work particularly well for a national security screening system. So, for example, the process was a very public process. Every stage of the Enterprise Act was played out in public. The timescales, the speed at which the legislation would move was unclear and very discretionary for ministers. It was impossible for investors and advisors to approach the UK government and seek regulatory clearance. And it was also unclear from the legislation which sectors of the economy, which things the UK government was concerned about from a national security point of view. And those were all inevitable characteristics of a piece of competition legislation. So as well as those characteristics of that legislation, clearly the world has changed significantly in those intervening 20 years. The geopolitical situation is very different. The way that economies work, the way that technology develops, and the national security threat have all changed and developed over that period. So what you see in the new National Security and Investment Act is an upgrading, an improvement, a strengthening of our powers on national security, removing from the Enterprise Act the national security aspect. On to the next slide, please. So as Christina said, the NSI Act comes into force on the 4th of January 2022. It completed its passage through the UK Parliament earlier this year, had royal assent in April, so it is now law. And in that intervening period between the end of April and the 4th of January, we have been issuing the detailed secondary legislation, the detailed regulations that sit underneath the legislation. So those provide, for example, details of the mandatory sectors of the economy and details of the kinds of information that investors will have to provide to the UK government. And fundamentally, as I say, it is a strengthening of the UK's national security powers and provides businesses with, as Christina said in her introduction, binding decisions with predictable timescales set out in legislation. A very significant departure, I think, from the way the Enterprise Act works. There are a couple of sort of key features about the Act before I go into the detail of it. Some key features that I think it is worth bearing in mind. It is not in any way focused on any particular country. It is, as we describe it, country agnostic. It looks at every transaction on a case-by-case basis. Equally, the Act contains no sort of fast-track system or no sort of whitelist of countries either. It is entirely country agnostic. Secondly, we expect that the majority of acquisitions will continue to raise no national security concerns and will be cleared very quickly through the legislation. I think it's interesting, if you look at the previous legislation, the Enterprise Act, in the 20 years that it was used for public interest grounds, it was used, I think, on fewer than 20 occasions. And in no national security case did the UK government ever block a transaction. So we don't expect that risk appetite or that approach to intervention or blocking of cases to change significantly. And excuse me, it's also, I think, a piece of legislation which is broadly comparable to some of the investment screening systems that you will be familiar with in other countries. For example, the US. It's relatively close, I think, to the CFIUS system. And then, as it says at the bottom of the slide, the Act will be run through BEIS, the UK's Department for Business, Energy and Industrial Strategy, through the Investment Security Unit, a new team established within the department to run those cases. And the decisions under the legislation will be taken by the Business Secretary, as they currently are under the Enterprise Act. Next slide, please. Now, I thought it'd be useful to spend quite a bit of time just going through the main provisions of the legislation, because it is a significant departure from the way that the Enterprise Act works. So first of all, the legislation is entirely focused on national security. Its powers cannot be used for anything else. It's not possible to add new categories of reason for using the powers. You would have to amend the primary legislation. So it is an entirely national security piece of legislation. As I say, can't be used for economic purposes, can't be used for wider public interest grounds. At the heart of the legislation is a power set out right at the start of the legislation in Section 1, which is the Secretary of State's ability to call in acquisitions of control over both entities and assets, either in the UK or, if they're overseas, where there's a sufficient connection back to the UK. And that's the sort of central power of the Act set out in Section 1. That obviously then raises the question, how does the Secretary of State become aware of transactions in order to be able to call them in order to exercise that power? There are three routes. The first is through routine market monitoring by the department of what is happening in the economy, what is happening in the markets. And that's, as you would expect, through open source material and commercially available information. But within the Act itself, there are two routes for acquirers to notify the government about acquisitions. There's a mandatory route and there's a voluntary route. So taking mandatory first of all. So the mandatory obligation to notify the UK government applies only to the acquisition of entities, and that is in 17 particularly sensitive sectors of the economy, where we've published detailed regulations setting out the precise activities in those 17 sectors that are subject to the mandatory requirement. So it is not, as some people often think, a mandatory obligation that applies to everything. It's about acquisition of control of entities in 17 particular sectors. And the Act sets out what it means by acquisition of control, and that is principally the acquisition of certain sizes of shareholding or voting rights or the ability to influence resolutions of companies. So acquisition of assets is not covered by mandatory notification. Now, of all the provisions of the Act, the mandatory notification provision is the most important to understand, because an acquirer must gain clearance from the UK government before completing the transaction if it's in one of those mandatory sectors. if that clearance, if the acquirer doesn't seek clearance before completing, then the transaction is void in law. The Act is quite clear about that. The transaction is void. It's as if it never happened. And as Christina said, there are also the potential for civil and criminal penalties as well for breaching that. But the most important thing, as I say, to note is that for mandatory notification, if it's not notified before completion, the transaction is void. As I said, though, the mandatory obligation doesn't apply to acquisition of entities. Now, of course, beyond that central category of 17 sectors of the economy, there is the backstop power for the Secretary of State to call in transactions. That's the first route, mandatory. Secondly, there is a voluntary route for acquirers to notify the government of transactions and to get clearance from the UK government within 30 working days, or if the government chooses to, a decision to call in that transaction. So voluntary route. That's, I think, also quite a striking difference compared to the Enterprise Act. That's the route for investors to be able to seek regulatory clearance. That wasn't available under the Enterprise Act. So statutory timescales, how does this act work? What is the speed behind it? So once an acquisition is notified to the government, we have 30 working days to decide whether to call in the transaction or to clear it. And that's an obligation set out in the Act. It has to be within 30 working days. And as I said at the start, we expect the vast majority of acquisitions, vast majority of cases to be cleared at that preliminary stage. Now, if the Secretary of State does decide to call in a transaction, he then has a further 30 working days to consider the national security implications that it might raise. And he can extend that first 30 working days by another 45 working days. Beyond that, any extensions have to be agreed with the parties. So as I say, once he's decided to call in 30, he can extend by 45 himself. But if he goes beyond that, he has to agree that with the parties. Now, during that assessment period, while he's looking at the national security risks, there are a number of things that he can do. He can issue an interim order, which is very similar to the kinds of preemptive orders that you would be familiar with in competition law. The ability to hold the parties separate and to prevent the parties from taking steps that might preempt any ultimate remedies that he would put in place. So an interim order to protect the national security situation. He can also request additional information from the parties. He can also require them to attend and give evidence so that he can increase his understanding of the case. At the end of that assessment period, once he's considered the national security risks, he has a number of options open to him. He can clear the acquisition to proceed. He can make a final order in which he can impose remedies on the case. And those, for example, could be behavioral remedies, or they could be structural remedies, or he could, in extreme cases, block the transaction or unwind it. But of course, those remedies have to be necessary and proportionate to the national security risk. As I said at the start, the Act is focused entirely on national security. Now, obviously, that power to call in cases is an important discretionary power. And one of the things that the Act requires the Secretary of State to do is to issue a statutory statement on how he will use that power. So that has been issued. It's now been approved by Parliament. And that gives an indication of how the Secretary of State will think his way through that decision. A couple of other things to note about the Act. That call-in power is available for up to 5 years after the acquisition has taken place. And it also has a retrospective effect. So it can be used in respect of acquisitions that took place between the 12th of November 2020. That is the day the legislation was introduced to Parliament. So between the 12th of November 2020 and when the Act comes into force on the 4th of January. As I said, 5-year backstop, but any decision by the Secretary of State to call in a transaction must take place within 6 months of him becoming aware of it. So he can't wait for a very long time. He has 6 months in which to decide whether to use that power. once he's made a decision on the case, he can't reopen it. He can't come back and change his mind and then make uncertain the regulatory certainty. The only exception to that is if he was given false or misleading information, and that's the basis on which he'd made his decision. Finally, on future-proofing, because the Act has this mandatory core to it with detailed regulations on types of sectors and activities, the Act has the ability for us to keep those up to date, as you'd expect. We can keep those regulations up to date, and also check that the mandatory part of the Act in particular is working in the way that was intended. So overall, this is a significant strengthening and upgrade to the UK's ability to screen acquisitions from a national security point of view. As I said, we expect the vast majority of acquisitions to be cleared at the initial stage, and it's an approach which is a legislative approach which is similar, I think, to that which you will be familiar with in many comparable economies. And overall, we believe it strikes the right balance between protection of national security and maintaining the UK's openness to investment and international trade. I will pause there, Christina, and hand back to you. Thank you.
Thank you so much, Chris. That was really a useful overview. I think that just before we turn to our expert panel of lawyers from various parts of Europe, may I just remind everybody to keep microphones off and cameras off if you are not speaking, and continue to get those questions into the chat. I see the first one coming, and I'll save that for our Q&A a little bit later. But let's hand over to the expert law panel, starting with Nikolai from Copenhagen. Over to you, Nikolai.
Thank you very much, Christina, and thanks, Chris. If you could flip the slide. I will be covering 7 countries, so I will not be potentially deep diving as much into the systems in the Nordics and the Baltic as Chris did, but his comments on continued openness also applies to the Danish regime and to the regimes being introduced or introduced in the other Nordic and Baltic countries. I think the question is whether the added complexity of transactional, sort of cross-border transactions will actually keep openness a reality, but let's look at that later. Please flip the page. When you look at the Nordic Baltics, we have 7 economies that traditionally score very high on foreign direct investment regulatory restrictiveness, as you can see from the OECD report from 2020. Please flip. In Denmark, we introduced a system in 1st of September this year that is quite comprehensive. The Danish government has said that it wanted to introduce a very robust system in the more restrictive end of what we've seen in the EU. So we have basically a system that relates to all foreigners. There are very few exceptions. And the rules are that if you take control over 10% or similar in Denmark, then the rules apply. They also apply to subsequently taking 20, 1/3, 50, 2/3, or 100. And if you are a foreign investor, that first goes from 0 to 15, and then subsequently from 15 to 25% control, you are required to do 2 applications. We have no lower thresholds in monetary terms in Denmark, meaning that any financial investment will be caught by the rules. We have, however, an exception for intra-group reorganizations where the ultimate owner of the Danish company remains the same. Please, the next slide. When we have 10% share control over shares or voting rights, then the government has introduced what they say similar. And that is where some of the problems for Denmark starts. First of all, we have a system saying that if you are For instance, a VC investor, and you get in the investment or shareholders agreement rights to veto or take certain decisions or to appoint persons in managing positions, then you acquire control that is eligible, that makes the transactions eligible. You can also acquire joint control if, for instance, you are two investors, each of them taking 6%, and you do it jointly, then you have above, and then you are propelled into the system. We also count potential voting rights, such as warrants eligible for exercise. The Danish rules has extraterritorial effect, meaning that any direct or indirect transfer of control over a Danish company makes the Danish system relevant. For instance, if a UK company is selling a division to another UK company, but a Danish subsidiary sits inside that group, then if you are inside the critical area, which I will come back to, you need to file for approval of that transaction in Denmark. The Danish Business Authority is looking at the moment at a question of whether having a branch here is enough. The Danish rules, since they apply to similar control to 10%, also actually applies to financing agreements where a foreign bank consortium would, for instance, give a loan and then have in that banking finance agreement tough covenants about controlling certain actions of the company loaning the money, which is a specific term that we have not seen so many places else in Europe. Denmark also applies our rules to greenfield investments, meaning that if you are a foreigner and you want to set up a subsidiary in Denmark, you within an area considered by Denmark to be critical, you will need to have that approved in advance. So that is something that we're not seeing in a lot of other countries. The Danish rules also applies to acquisitions over listed shares. So if you are buying, for instance, 10% of voting rights in a company listed in the UK, and that company has a Danish fully owned subsidiary, the transaction abroad on the stock exchange would actually need to be approved by Denmark before it can proceed. To this end, we have introduced a fairly comprehensive system of transactions that are subject to the Danish rules. If you can flip the slide. As I said, most foreigners are governed by the regime, very few foreigners directly. The problem in Denmark is that also a Danish company with foreign control is comprised. So if, for instance, you have a Swedish citizen owning a 25% share interest in Denmark, the Danish company also becomes subject to the rules. We have elsewhere rules that apply without any reference to territory. The Danish rules does not apply to Danish transactions, but as I said, a foreign ownership in a Danish company will make you subject to the rules. Please flip the slide. Denmark has designed 3 critical sectors: defense, IT security, and dual-use products. That is where, if you are within those sectors, you are considered critical, and the rules apply. Defense relates back to the EU list of war materials, and the dual-use product the same. We don't have thresholds here as well. So if you are a company with 1,000 products and one of them is dual-use, you will be considered dual-use. We have then defined 11 critical infrastructure sectors, ranging from transport, financial, public authorities. And if you are a company that are has operational responsibility for public for infrastructure, or if you're developing technologies that will constitute infrastructure, you are also a critical company. And then we've defined a number of technologies ranging again from AI to space tech to 3D to synthetic biology and advanced industrial robots, where if you are operating within these or developing these kind of technologies, you are also a critical company. We have some guidance as to the limitations, and they are set out on the next few slides. I don't want to go into those in depth, but I can say that the Danish system is not as fleshed out as the UK one. There is much more ambiguity in the Danish, in relation to the Danish definition of critical technologies. Please flip the slide. And flip again. And flip again. Here we have the critical infrastructure. So if you have direct or indirect ownership or operational responsibility for via outsourcing, or if you develop or manufacture technologies that constitute critical infrastructure, you are a critical infrastructure company. And for instance, if you are developing technologies for power to X, and that when it's developed and marketed, it will constitute critical infrastructure, which it is, then a company operating within development of power to X technologies would be comprised as a critical company, even if they're not operating any critical infrastructure. Please flip slide. The last category of agreements that Denmark has captured are what we call special economic agreements. These are special commercial agreements that are not investment type deals. They are R&D joint ventures, supply agreements, and operational and service as outsourcing agreements that, if they have certain components, are also considered to be FDI relevant. These kind of agreements are null and void if you enter into them without approval, whereas, and that is not in line with the UK system, the transactions, if we do with the ordinary FDI transactions, they are not null and void, but they can be stopped, so to speak, by the Danish authorities. Please flip the slide. Denmark also has deadlines for processing, and I can touch upon those later if relevant. Now Norway, this is Bergen Engines, a company owned by Rolls-Royce. Bergen Engines was not on the list or that the Norwegian government published of critical companies that required approval, but the Norwegian government has a very broad call-in right at the moment. Rolls-Royce asked the Norwegian government to nod that they were able to sell Bergen Engines, and then proceeded after receiving that informal approval. As it transpired, Norwegian media got hold of the transaction, and since the Swiss owners that were the Swiss company that were buying Bergen Engines were controlled by Russian oligarchs, then the Norwegian government stepped in and blocked the transaction. Since Bergen Engines are supplying diesel engines to the Norwegian Navy and are servicing the NATO North Atlantic Fleet when they are in engine trouble, and Bergen Engines' plot of land is also situated at the entry to the Bergen Harbor. Please flip the slide. That has caused Norway to propose new legislation. They will maintain the negative list system, but in an expanded format, and now includes also a voluntary filing system. And the very broad Norwegian call-in right is, of course, will of course propel a lot of foreign buyers to use the voluntary filing system and ask for approval before they proceed in Norway, also on the basis of the Bergen Engines case being blocked. Please flip slide. Sweden has just published its new FDI regime proposal, which basically takes Sweden from 0 to 100 in just a few seconds. The Swedish legislative proposal has real teeth. Also, Sweden operates with a 10% control threshold and no lower financial limit. It will come into effect, it's proposed from 1st of February, but 2023. The Swedish systems looks fairly much like Danish ones, with a lot of protected activities. A Swedish company must inform the investor that it carries out some of these protected activities, whereas in Denmark, the whole application procedure is only applicable to the foreigner, and the foreigner is responsible for that. In Norway, in Sweden, you can get administrative fines. That is not a tool available in Denmark at the moment. And one of the cases that has propelled Sweden into making this proposal is Tencent's investment in the Swedish health platform Doctor.se. Please flip the slide. Finland had an FDI regime even pre-COVID, but when the pandemic hit, Finland expanded the scope of the FDI regime there. They've also identified some key national interests, but the Finnish system actually excludes true EU and EFTA investors. So if you are a Danish company owned by Danes doing a transaction in Finland, the rules does not apply. Also, the Finnish rules have, the thresholds are 10, 1/3, and 50. And Finland has introduced, like Denmark, has introduced an option to receive a formal pre-screening exclusion decision. Finland has had also for a very long time special rules for real estate investments. And the Finnish regime is quite similar to the Danish ones. And Finland has actually managed to do quite a good system in terms of being able to get approvals through quite rapidly. Also, when we are dealing with clients from countries that are, as a starting point, considered problematic, like China and Russia. Please flip the slide. Latvia also has a regime that is fairly fleshed out in terms of some very specific issues where prior approval is required for transfer of ownership. And the Ministry of Economic Affairs in Latvia maintains a list of commercial companies that qualify as significant to the national security. Now, the national security, and it was Chris who said that in the UK was national defense. The EU countries, as a starting point, can block if you have either national security or public order constraints. And I think the public order possibility in the EU is wider, because that also relates to, for instance, free media and stuff like that. Please flip. Lithuania also has an FDI mechanisms that applies to all investors except for certain state-owned or controlled entities. The screening is triggered by some of the same acquisitions, transaction types that we saw in Denmark, transfer and pledging of shares or selling them. The scope and mandatory the scope and mandatory or discretionary nature of the Lithuanian screening mechanism, this differs according to which target you are eyeing in Lithuania and the type of transactions. So it's a fairly comprehensive system in Lithuania. And then lastly, Estonia, being the only country in the Nordic-Baltic region without an FDI regime yet. Estonia published an impact study in March 2021 and was proposed to do legislation here in the fall of 2021. For various reasons, it has not come out yet. It is thought that the Estonian system will be fairly similar to that has been introduced in Denmark, Finland, and Sweden. The only restrictions we have in Estonia at this point in time are restrictions on purchase of real estate, either related to agricultural and forest land, or where you have real estate that is vital to national defense institutions. Please flip. In terms of impact on M&A and in cross-border investments, we are seeing complexity increasing. At the moment, we have to do these FDI surveys on a number of transactions, also due to the absence of financial thresholds on deals that are in sort of the small and mid-cap market. That gives rise to cost and deal uncertainty, and it may result in a move for sellers to choose what we perceive as less complex buyers, for instance, in relation to the destination of the buyer. Limiting the range of buyers will of course have the risk of impacting adversely transaction valuations. We see in these FDI regimes that when you have statutory filing, you cannot complete the deal before approval. And that means that in what the system we're used to from merger control will apply also to these smaller and mid-sized deals, where you will have to stop as a buyer when signing the deal and you can take no further control. We are very used to having a lot of control conveyed to the buyers already at the signing stage, but that will now have to stop if you are subject to the FDI regimes, which will lead to an increase in the use of the more ambiguous material adverse change clauses, leading again to more deal uncertainty, allowing buyers to walk away in an increased number of scenarios. And the stop clause in many systems also will impact on the ability of buyers and sellers to exchange information if you are dealing with a critical company. And that was my presentation on the Nordic and Baltic FDI regimes.
Thank you so much, Nikolaj. Before we take a quick trip to Paris, I will just remind you that you can post any questions that you might have or reflections in the chat, and we will pick them up later in the Q&A session a little bit later today. But now we'll take a trip to Paris and visit Lionel Le Sur, who is going to talk to us about what's happening in the French system. Over to you, Lionel.
Thank you very much, Christina. Good morning to you all, and very happy to be part of this webinar. Thank you for inviting me. So as far as France is concerned, I think that the trend is about the same that in the other main country, insofar as we have seen a regular increase, if you can turn the slide, over the FDI screening over the last years. It's a constant rise. As you can see, the number of control proceedings reached 275 in 2020, with a spread of the investment coming for the wide majority from Europe, and for about 40% from outside Europe, with North America and the United States first, and then Asia. Of course, in a similar way, I would say also with other countries, attention is dedicated to the defense sector, with about a third of the investment concern. But we have to point out that this proportion is slightly changing, with an increased attention to other non-defense sectors, starting with the life science and the health sector. And we expect these trends to continue, in particular as a result of the pandemic. In addition, there is some state encouragement and financing available for investment in the R&D and innovation sector, which should continue driving investments in this sector. And therefore, as long as this sector is covered by the FDI French regulation, we expect the proportion of investment in this sector to be reviewed to increase, while of course defense will remain a key sector because of the strategic dimension it has. If you can slip the slide, it would be great. Thank you very much. We do have an FDI screening which works basically in a way very similar to other main countries, insofar as it covers investment by foreign investors, be it an individual or a legal entity, which is triggered by the criteria of the change of control as defined in the French Commercial Code, which is basically triggered as soon as there is a change in the majority of voting rights, with an alternative that is the right to appoint the majority of the corporate officers. In addition, there is also a presumption that as from the threshold of 40% of the voting right, you are deemed to acquire control, which also triggered the FDI screening as long as the target operates in one of the reviewed sectors. There is also, beyond the legal notion of control based on voting rights, there is also an alternative, that is the concept of contractual control, which may result in the possession of a determining influence through contract. So the concept of control is a bit broader than the sole crossing of the 50% threshold of the voting rights. It also applies this change of control criteria as long as there is an acquisition of all or part of what we call a branche d'activité, a business, which covers therefore an asset deal. As to the type of investment, so beyond this change of control over a company or over a business, the FDI screening regime, as far as non-EU investors are concerned, also extend as soon as you have an acquisition of 25% of the voting rights of a French target. This applies to non-EU investors, it being specified that EEA country members are assimilated to EU investors. This threshold before 2020 was of 1/3 of the voting right and has therefore been reduced to 25%. It has further been reduced for investment by non-EU investors to 10% as long as and as soon as the target company is a listed company. This is one of the major change and perhaps a distinguished feature of the French regime. It has been introduced as a result of the COVID-19 pandemic, so in spring 2020. It was supposed to be a temporary change until the end of 2020, but it has been recently extended to the end of December 2022, and one may question whether it won't be permanently included in the French regulation. So at least for the time being, as long as you have a non-EU investor acquiring more than 10% of the voting right of a French target operating in one of the reviewed sectors, you do have, as an investor, to inform a specific services, which is a part of the French Treasury, and it is up to the French Treasury to review this investment and indicate whether the investor has to file a proper and full complete investment request, similarly to the case where there is a change of control or an acquisition for non-EU investor of more than 25% of the voting rights. As far as now as the third pillar of the control, which is of course the list of the sector reviewed, nothing very specific to indicate here. Of course, France is very concerned about the protection of its strategic priorities, so it covers also further to the harmonization within the EU, the classic sectors that are related to the defense, to the R&D's activity, and it has been further extended with the pandemic to the written press, to the agricultural products, to make sure that we ensure food sovereignty, and also, and last but not least, to biotech R&D's activity, which allow me to make a link with my initial discussion about the fact that the proportion of investment being reviewed in the life science department is increasing. We do expect in the next future perhaps a slight broadening of the sectors reviewed under the influence of the EU regulation. Could you slip the slide, please? Thank you very much. As to the procedure, we have a two-phase procedure as long as you enter into the former review procedure. As a preliminary, I would like to point out that we do have in France a kind of informal procedure, which is through asking preliminary questions to the French Ministry of Economy. But as a matter of fact, we often advise to our client and foreign investor not to use it, and as a matter of fact, it is not very commonly used in France because the time frame of this informal preliminary question, which is in theory 60 days, although in practice you may obtain a feedback before that, may mean that it's not interesting from a timing standpoint, including where time is of essence to the transaction. And so therefore, and except in the limited circumstances where you have a good confidence that your investment should not fall within the scope of the FDI regulation, we rather opt for a direct application. And this application is dealt with in two phases. The first phase is that lasts for 30 working days, as from, and I insist on that, the receipt of a full application. And experience shows that you better gather the necessary information and engage into informal discussion to make sure that your file is complete before actually filing your request, because otherwise the clock will not start ticking immediately. So it's important to make sure, including where a timing is of essence to the transaction, that your file is complete as soon as you officially file it to trigger the start of this binding 30 working days deadline, at the end of which the French Ministry for Economy would either authorize the transaction with no condition attached to it. First possibility. Second possibility, it would indicate that the contemplated investment does not fall within the scope of the FDI screening procedure, and so therefore you may proceed with your transaction. And third possibility, the ministry would indicate that an authorization is required, but that it needs more time to review the investment at stake, which in this case open a phase 2, which may be up to additional 45 working days, at the end of which either the investment is authorized without any condition, which is possible, or is refused, which is another option, but we will see later on that is very rarely happen, or it is authorized but with condition attached to this authorization. So maximum, as long as you file a full application, the two-phase proceeding will last a total of up to 75 working days, which of course you do have to factor in the transaction calendar. Could you flip the slide, please? So I will insist a second on the case which is more interesting to us, is when contemplating investment does fall within the scope of the FDI screening French regime, but it's not a straightforward one, and therefore an investor has to engage into discussion with the ministry who wants to impose condition before ideally clearing this investment. We have to immediately indicate that the objective of the French government is not to prohibit this investment, but find a way through the imposition of condition to authorize it in a way that will basically allow to save and keep in France the know-how, but also the workforce. This is the two objectives that clearly result from our experience in FDI screening. So in imposing what we call these measures, these remedies, which are, as the case may be, formalized into a remedies letter that is attached to the authorization delivered by the ministry freely determines what is necessary. It can go up to the sale of a part of the acquired company or branch of activity, but what we see more are commitments to maintain workforce or know-how in France, or a request to revise the contemplated future governance of the target, which may include, for example, have a representative of the French state at the board. And of course, this condition can be changed over the time. This is one specificity perhaps of the French regime, insofar as further to a request after closing by the investor or by the ministry itself, in the event where there are some unforeseeable change in the economic or regulatory condition of the activity, or other element that may justify to review the remedies, these remedies can be reviewed and possibly changed in order to make sure that what we are targeting, meaning keeping the know-how and the workforce in France and allowing the French government to keep an eye on the strategic target, will be fulfilled. In doing so, the ministry must ensure that it acts in a very proportionate way and only impose remedies that are justified and proportionate to the legitimate interests that France would like to protect. And at the end of the day, the amended condition, if they are amended with respect to the initial one, will become, of course, binding to the investors. There is no limit to the number of times in theory where you can ask for a revision of the remedy, but in practice, with the limited experience we gain for now a couple of years only, we have no such example of a series of revisions, but it may happen in the next future. Could you flip the slide, please? We do have, similarly to other countries, at least in theory, quite hard sanction in case an investor does not comply, be it an EU or non-EU investor, with the legal and regulatory provision of the French FDI screening regime. In case the investment is carried out without prior authorization, first, the French government may impose a quite high daily fine, which is up to 50,000 €, and ask, but again in theory, to demerge, so to come back to the previous state. What we see in theory is that there is a clear trend from the authority as soon as there is a non-compliance to first engage very quickly in informal discussion as an alert and ask to the investor who would have not complied with his obligation to ask for a prior approval to file this approval request immediately upon the threat of this daily fine and of a potential order for demerger, in order to force the control to actually take place. In case of a strict danger to national interest, the French Ministry for Economy can also take some various precautionary measures, as the suspension of the voting rights, for example, but we lack some feedback on this situation to give you a more specific illustration of what may happen in practice. This precautionary measure can also, for example, include the appointment of a trustee that would be responsible within the target of its management, pending the outcome of the control. When the conditions that have been attached to a potential authorization have not been complied with, the authorization can be withdrawn, an additional condition can be imposed. And last but not least, in all cases, in addition to the daily penalty, a fine up to twice the amount of the investment or 10% of the gross turnover of the target can be imposed. Could you flip the slide for the last one, please? Just to give you an example and the list of the main information that is requested as part of the application file, pointing out what is put in bold, because experience shows that the attention is dedicated to the list of competitors, who are there and what are the market share, in order to make sure that sufficient competition would remain in France, and the list of the IP covering the know-how that is owned or exploited by the target. Other information are more classic in order to allow the ministry to have a broad and full view on the investment on the target and the investor. Could you please flip the slide, please? One word now on, to date, the only example of a refusal by the French ministry. That was regarding the potential acquisition of the French mid-sized company Photonis, which is a leader in the manufacturing of night vision, by a US investor. And to make the long story short, there was some opposition by French Parliament member to this potential investment, which basically resulted in long-standing discussion between the ministry and Teledyne, as the potential US investor, with the French ministry asking for remedies, including, for example, to have a French state representative at a board and the impossibility for Teledyne to fiscally integrate Photonis. As a result, because it was refused by the investor, the ministry orally refused the acquisition before later on down the road confirming officially in a letter this refusal, which result in Photonis being acquired by a French investment fund for a lower price rather than by the industrial US partner. This is the first and sole example to date in France of a refusal, but it gives some very interesting indication as to how we need, when advising foreign investment, to deal with this FDI French regime. And I would end up, flip the slide please, with some practical advice that we have gathered based on our experience, which is basically, first, start the analysis of the applicability of the regime as soon as possible. In case you do think it is applicable, gather the information as soon as possible, starting at the due diligence process at the later. Third, we need to very carefully factor the likely timing of the control in the overall M&A transaction calendar. It may run, of course, in parallel of any merger control proceedings, all the more that it may be shorter, but we need to define very carefully any long stop date in view of whether or not a phase 2 of the control is likely and whether remedies may have to be negotiated. The fourth point is that we need to adapt accordingly the clause of the SPA as soon as the FTA screening is likely. We need a condition precedent. And to make some comparison with merger control, we believe that except in perhaps in very specific cases, it would be more acceptable for an investor to accept a hell or high water clause because the intensity of the control and the extent of the remedies is usually lower and softer than in merger control proceedings. Of course, we do encourage and accompany our clients to engage into informal talks with the ministry as soon as they can. The ministry shows professionalism, is pragmatic, and very encourage these informal contacts to make sure that the situation is dealt with in the smoother way. And when you have to turn to negotiation of remedies, which are usually formalized in quite short letter, like 5 pages approximately, knowing that decisions are not published, you do need to focus on key points only because we can see that contrary again perhaps to merger control, the negotiations are not that long and detailed, and really what matters to the French government is again know-how and workforce to keep in France an eye on the target and keep in France the strategic elements that are know-how and workforce. I would stop my presentation as to France here. Sorry if I've been a bit too long, and happy, of course, to address any question or comments. Thank you very much.
Thank you so much, Lionel. That was really interesting, and some good practical tips as well for people to take forward. I'm sure that's valid for most of the regimes that we've seen. Now let's take a quick trip to Cologne in Germany, and Christian, take us through what is happening in your country for FDI screening.
Yes, thanks, Christina. Maybe 2 remarks before I start my presentation. One is a big apology. We have now been overflown with information, I think about 9 jurisdictions, and now at the end you hear that there's a 10th jurisdiction, which is very similar but also different. But I think that's a new reality we face in the FDI screening world. And the second is, so I'm a lawyer advising companies before the ministry in FDI filings. So my perspective is a little bit different maybe than Chris' perspective when he talks about the UK regime. So that maybe is the reason why I'm a little bit more critical about the regime than Chris was in his presentation about the UK regime. So let's look at Germany and begin with the first slide. So as in France, we have for quite a long time an FDI screening mechanism. The legal basis is the Foreign Trade and Payment Act, and based on this act, the government issued the Foreign Trade Ordinance, which regulates the proceedings and defines in more detail which transactions are subject to FDI screening. So in the past few years, the regime was amended many times. So in 2020, there were 7 amendments of these 2 regulations. And in 2021, again, 7 amendments. So even for specialized lawyers, it is hard to keep track of all the amendments. However, one thing is easy, that's the clear direction of all these amendments. And that's expanding the scope of FDI screening and lowering the standard of the Ministry of Economic Affairs to restrict foreign investments. So against this background, it's no wonder that we see a steep increase in case numbers. In 2016, we were below 50 cases, while in 2020, we already had 160 cases. So within 5 years, the number of cases has tripled. So we don't know the number of cases for 2021. However, a representative of the Ministry for Economic Affairs stated early November that the ministry had reviewed around 250 cases. And in addition, 200 cases originated from the EU FDI screening mechanism. So at total, they looked until November on 450 cases. So while in comparison to merger control, these case numbers are pretty low, right? In 2020, we saw in Germany alone 1,200 cases. But when you look at the intervention rate, it's quite a different story. In 2020, the German Federal Cartel Office issued only 9 decisions in the main proceedings, and thereof, the Cartel Office prohibited non-transaction. Only in 4 cases, they cleared the transaction subject to conditions. And in 2 cases, the parties withdrew the application. So you can say in 6 cases, only the parties could not implement the merger as planned. We don't have the number for last year in FDI, but in 2019, there were 15 cases where the parties entered into a public law contract. So in 15 cases, the government intervened. So the intervention rate is pretty high, in my point of view, in FDI proceedings. Although I have to say, and that's I was pleased to hear it from Lionel about the French practice. So when we talk about intervention, what are the remedies? They are very similar to France. It's always like keep the know-how in Germany, keep the workforce, make sure that the IT systems are safe. They relate to the governance of the company. Or a typical example is that you have to produce the products ITAR-free so that they are not subject to the US ITAR regime. And probably, I think in the future, when we see more and more cases, also the intervention rate will be lower. So let's look briefly at the sectors, because it's also quite different in comparison to France. We have only 3% of the cases belong to the defense sector. So the main sector is information and communication technology, followed by the healthcare sector. But I think when you look at the cases where the ministry intervened, so I don't have the numbers, but at least my last 2 cases where I had to negotiate a contract with the ministry, both belonged to the defense sector. And also the last case where the ministry issued a prohibition decision, that was a small company, IMST, in Germany, that was active in the communication sector. They had a very high know-how about the 5G standard. But one of the reasons why the government stepped in was that it said, okay, this technology could be used by the Chinese investor for military purposes. So also the defense sector here with 3% is very low. I think it is much more important in the cases that really matter. So the key takeaways from all these numbers is FDI screening covers more and more transactions, and FDI screenings are not a pure formality. The intervention rate is quite substantial, and they affect the timing of the transaction and also in some cases the outcome. So let's take a look at the next slide. How do the proceedings look like in Germany? So I will wrap it a little bit up because we are a little bit behind schedule. So as you see, we have 2 basic different proceedings. One is a sector-specific assessment. Why sector-specific? This concerns targets which are active in the defense sector. In this case, the proceedings apply to all foreign investors, so also for investors within the European Union and EFTA states. It's sufficient if you acquire 10% of the voting rights, and there is a standstill obligation. And you have to notify before you can close. The standard here is that the transaction is likely to impair essential security interests of the Federal Republic of Germany. So from my perspective, a test which leaves a lot of room for interpretation and is quite low. So the second proceeding is a cross-sectoral assessment. And this applies only to investors from outside the European Union or EFTA states. So here really one big difference in comparison to most of the Nordic regimes and France. In this procedure, a distinction must be made whether the target is active in one of 27 defined case groups. If the target is active in one of these groups, you have a notification requirement and a standstill obligation. So these 27 groups cover the usual suspects. So it's critical infrastructure, cybersecurity, semiconductor industry, healthcare, and so on. But here I have to compliment the German government. The government made really a big effort to specify and narrow down the case groups of the European screening regulation. So in particular, if I compare to the Austrian regime, this is really more narrow and precise to the point. I think similar, as Chris told, that the UK government has really given thought on how they can define the really critical cases. So the legal standard is here that the transaction will likely affect the public order or security of the Federal Republic of Germany. So, and if the target is not active in one of the 27 case groups, then there is no mandatory notification requirement, and there's no standstill obligation, so the parties can close, but the ministry can pick up the case, and if it comes to the conclusion that the transaction likely affects public order or security of the Federal Republic of Germany, it can dissolve the transaction. So the ministry has 5 years to do so after the purchasing agreement is agreed. And this period is shortened to 2 months after the ministry has gained knowledge about the purchasing agreement. So to achieve legal certainty, the companies can apply for a certificate of non-objection or simply inform the ministry about the contract and wait 2 months and then close the transaction. So the timing in all these proceedings is pretty similar. So you have a first phase, which is 2 months, and then if the ministry initiate proceedings, it has 4 months, and which can also be prolonged. So we slip to the next slide, please. Here, just I think this is very similar as in the Danish regime. You always need to have a German target. But this could also be a German subsidiary of the target. And also, if you have a shareholder who is foreign, then the FDI regime can apply. So exactly the same, I think, as in Denmark. So therefore, we can go to the next slide, which is one special situation, which is different in German FDI screening than in merger control and also than in the Danish regime, and that is internal restructuring. Before the latest amendment, there was no exception at all. So every internal restructuring could trigger a notification requirement under the FDI screening mechanism. Now, the legislator introduced one exemption, but it's very narrow, and that is that basically it covers from the wording only one transaction. That's when the holding one here shares the shares in the target to the holding company 2. So because all companies involved in this transaction are in one jurisdiction, and the parent, which controls holding 1 and holding 2, is also in the same jurisdiction. What is clear is that when holding company 1 sells the shares of the target to holding company 3, this is covered by German FDI. What is not clear is, for example, if holding company 1 sells the shares to the target, to the parent company. That's not covered from the wording of the exception, but it is very clear that from the goal of this exception, it should be covered. So, but there's a legal uncertainty. What can you do if you know that early in the process? You can just inform the ministry, and then after 2 months, you can close the transaction. So, and that brings me to the last slide. What are the key takeaways when planning the transaction? And here I can make it also really short because it's exactly the same as Lionel put already out in his presentation. It's really important to consider FDI screening early in the process, to collect the information early, and also to communicate it clear to the partner and to the authorities. Nothing is worse that when you have filed the notification, you are in negotiations with the government, and then the government finds out that you did not have disclosed a product that is sold to the German army or something like that. So that's really important to be here very precise and comprehensive. And also when negotiating remedies, really concentrate on issues and clauses that really matter, because for each round, the Ministry of Economics has to go back to the Ministry of Defense, to the Foreign Ministry, and to get all the reports and from this ministry before it can go back to you and negotiate again the clauses in the contract. So yeah, that was a really short run through the FDI regime, and I would end here my presentation and give the floor open to questions, and to you, Christina.
Thank you so much, Christian. And this is our chance for everybody to ask questions. So I'll just invite the panel to put on their cameras again. And to all of you, if you have any questions, just feel free to raise your hand. You can use the button on the top of your screen with a hand, or you can just interrupt me if you have a question. But I think I have a first question for you, Chris, about the UK regime. So there is a question in the chat, if there is an estimate of the likely number of mandatory reviews that will need to be processed by the UK, and also how many cases have there been in the UK in the last year or two in the 17 restricted sectors? Do you have data on this?
Thanks, Christina. So on the headline figures, so our published estimate, which is for both the mandatory and voluntary combined, is between 1,000 and 1,800 notifications per year. But as I say, that is the total estimate for both mandatory and voluntary. We don't have a separate estimate for mandatory or voluntary on their own. And also we don't have a sort of retrospective estimate of what would have been caught if you had applied the current legislation previously. But as I say, the overall estimate somewhere between 1,000 and 1,800 for both mandatory and voluntary taken together.
Yeah, and will we see a sort of surge in numbers as we've seen in Germany, for example, over the last years? Are we estimating something similar?
I think you'll see. Well, who knows what will happen from the 4th of January? No one ever knows what happens when you switch on a new system. I think you will inevitably see a large volume of cases, and I would expect that to settle down over time as people get used to the way the system works, how the government operates it, and as you build up a bank of case decisions. That's what gives people certainty about how to operate the system. So I would expect a sort of a downward curve. But as I say, when you change the law and switch on a new system, you wait and see what happens.
Chris, this is Nikolai. Will you be publishing decisions, because in Denmark they are public? No, they are sort of not non-public, and they are confidential. And for that reason, we are afraid that we will have little guidance as to the decisions taken by the Danish ministry. But are you planning to publish your decisions?
So the Act only requires the Secretary of State to publish final orders. So that's right at the end of a case when he is making a decision. Throughout the rest of the process, the Act doesn't require him to make those decisions public, which is, I think, quite a conscious decision by the government, comparing this legislation to the Enterprise Act, where all the decisions and the process was played out in public, as you tend to do in competition decisions. So, as I say, legislation only requires the final order to be published.
Yeah, and maybe there is a question in the chat also about the UK National Security Investment Act. And the question is there an appeal process outlined, or is the minister's decision to block a transaction final?
So you can appeal on the merits, but only on the Secretary of State's decisions on penalties or the recovery of costs. Other decisions under the Act are subject to judicial review, so that is not a merits-based court process. That is where you're challenging, in a sense, the way that the decision was made. So merits-based appeal for penalties and recovery of costs, the bulk of the act subject to judicial review.
Understand. Last question that I see here in the chat is around timescale. The question is there a set timescale within which a mandatory notification will be reviewed before the notification will either be accepted as complete or rejected? Within the 30 days, I guess.
Yeah, when I read this, I think what this is about is how long will the government take before deciding whether to accept the form and then begin the statutory process. So the Act doesn't set a specific time. What it does say is the Secretary of State must, as soon as reasonably practicable, decide whether to accept the form. So he's under an obligation to move and to, as I say, to make that decision as soon as reasonably practicable. No specific deadline on that, but I would expect that to be a matter of days. We're not going to want to hang around and leave notifiers, acquirers waiting. It's important to get notifications into the system so that you can get into that regulatory certainty and the timescales that the Act lays out for you.
Absolutely. Any other questions from any panel members or participants? Please just raise your hand or shout. Okay, there is one here. What is the position of the EU Commission on the many new national investment screening laws? Anyone, I guess.
I can take a crack on that. I think, these EU-based systems pop up as a result of the regulation introduced in 2019, but they are popping up in different shapes and sizes, making it fairly complex because you have different systems in all EU countries. And you are all, the Commission just published its first report a couple of days ago, and I think they are talking about an alignment process down the road, but it's not an easy one because inherently each country will decide what is national security and public order locally. So I think even if the Commission is already at this point in time talking about alignment of procedures and what is critical, I'm afraid that will not be an easy task for the countries to agree on. I think that's my view. But the EU Commission is generally pleased that we have now, systems in place or being adopted across, almost all countries. I think we are lacking 3 or 4 across Europe.
Yeah, I absolutely agree with the assessment of Nikolai. Maybe one addition. So what I hear from representatives of the German Ministry for Economic Affairs, they're very grateful for all the statements the European Commission makes in specific cases, and also about the exchange under the screening procedure with other authorities in other countries. And my hope is that similar as the ICN network in merger control leads to a more alignment of the practice and involves best practice rules, that we will see that also in FDI proceedings, but it will take a long time. And I absolutely agree. National security interests are different than than competition law. So it's much more locally and nationally.
Absolutely. We are hitting the hour. It is 12 o'clock, my time at least, I think 11 in the UK. So our time is up. I want to thank all of you, our experts on FDI screening, and all of you participants. I hope that you found this webinar to be of use for your business. You're always welcome to contact the Department for International Trade if you have more questions. I see that there are some more in the chat. We'll deal with them afterwards. And we will, of course, share the slides from this webinar on our website. So go to that one where you were invited to sign up. We are here to help you to land investment in the UK, and I hope that will continue. So do also keep in touch with Chris and his investment screening unit in BASE. It only remains for me to say have a very good day wherever you are, and hope to see you again soon. Bye-bye.
Thank you. Bye-bye.